What is your claim? Charge and mark. You're retiring or that person is retiring? Why are you worried about it? You are not doing it. Yes. Why?
I am directed to enclose here with the copy of the prior petition submitted by the Marna Kishore Das and 8 others forwarded by SME Assam, and to request you once again to furnish the views of state level scrutiny committee on the matter so as to enable this department to take a hearing as per the order of Honorable Court.
Yes, what is this, Mr. Peter?
Your Lordship, as per appeal, Your Lordship 24/9/2024, which was submitted by the petitioner, and under section 14 of Assam Educational Provisional of Service of Teachers and Reorganization of Educational Institution Act 2017 was rejected, and we can enforce the order copy, Your Lordship.
Lordship, I have not.
You don't know?
Not communicated, Lord.
I would like to first.
So you withdraw on liberty to file afresh.
Lordship. Then they file affidavit, Lordship, I have countered it.
No, not affidavit.
Lordship.
You are seeing that order.
It's passed, Your Lordship.
Just received, Lordship. I have not the opportunity for counter. Lordship.
You don't require an opportunity, Mr. Counsel.
Lordship.
You withdraw it or dismiss it
Should be dismissed, Your Lordship, as
with cost.
Then I would go,
Pass.
Lordship.
already.
This writ petition has been filed for the second time
Second.
on the premise that the order passed by this court in the earlier round of litigation on 25/7/2022 in WPC number 4701 of 2022, requiring the appellant, requiring the petitioner to file an appeal. Under section 14 of the Assam Education, open bracket, provincialization of services of teachers and reorganization of educational institutions, close bracket, Act, 2017 has not been considered and disposed of. Stop. Ms. P. Das, Learned Standing Council, Secondary Education Department, however, has produced an order dated 11/12/2024, by which the appeal filed by the petitioners have been rejected. Stop. A copy of the same is. DC Nath? You are Mr. DC Nath? Learned Counsel for the petitioners. Most of the Learned Counsel submits that under the circumstance, he may be allowed to withdraw the writ petition with liberty to file a fresh. Prayers allowed. Writ petition stands disposed of as before. Liberty is also granted to file a fresh. If so advised. Copy of the order dated 11/12/2024 is being retained in the record and marked as X for identification.
Problem.
Keep your blades.
Lordship, I have been instructed to take some more time.
How much time?
Let it come after petition.
I think your friend also agrees. As paid for by Mr. B. Chaudhary, Learned Counsel, for the
It is
responding BTC, further 3 weeks time is granted to obtain instructions and to file response. List again after 3 weeks.
May it please your lordship. This case relates to compassionate appointment. Earlier, I approached this honorable court by way of filing the petition number, the second one, 6183. They filed affidavit and stated that my pair is rejected on the grounded under qualification, my lord. The petitioner herein, my lord, is a wife of the wife. Her husband died 29/5/2016, my lord. Then, my lord, what happened? She applied 27/7/2016 for compassionate appointment, my lord.
Right on 29/5/16.
Yes, my lord, 29/5/2016, and she applied 27/7/2016.
Then
What happened, my lord? Nothing has been done. She approached before this concerned authority, filed several representation. Then there is no way out. She approached this honorable court, my lord. Then honorable court, when I filed this case, they have filed one affidavit that is space annexer G 28. That it is stated that they have annexed, my lord, I mean to say district level selection committee, my lord. Lordship kindly peruse 32, page 32. Her name is Rina Boro. It is shown that under qualification because she passed, she has been promoted to class 10, but she has not passed class 10 at that time. Then it is stated that I am under qualification. That is why they have been rejected my pair. And I have seen, my lord, that there is another defect is that the application of the date is also, it is written 11/4/2017. Lordship, can you got it?
where is that?
That is second application statement for gate 4. AA. 32 page.
Page 32.
32. Application statement for
No. What? There's no page 32. Okay, page. Okay.
32.
Reply affidavit.
Yes, their affidavit, my lord. Their affidavit, they have annexed, my lord.
No. 30. Their affidavit is only up
28,
till.
29.
page number 29.
Their affidavit is up till 30
Actually,
only.
29, 28 is the, 29 is their affidavit. Then they have stated para 5.
7.
Yes,
Serial number 7.
my number is 7. Yes. my lord.
Underqualified.
Lordship, kindly
Then?
state date of application, my lord. They have inserted the
date is 11/4/2017.
Ah.
But whereas I applied, my lord, 27/7/2016. And they, in remarks, my lord, they have stated that I am under qualification.
Yes.
But
Not here.
the office memorandum, lordships. Lordship kindly peruse 39 page. In
Thir-
office memorandum, my lord,
39.
39.
Ah.
19, para 19, where a widow is from the requirement educational qualification.
You are the widow.
This is it.
You are the widow.
My lord, earlier it was up to class 7, they will get the, my lord. This time they have stated that I'm under qualification.
You are widow.
I'm widow.
Widow.
Yes.
What is your qualification? Class
My
9.
qualification, I have been promoted to class 10.
Here it is written as class 9.
I have completed class 9. Promoted to class 10.
Then as
It is
per
written-
this,
Everything is written, my lord, falsely, because I applied, my lord, within a 1 year. They have stated that date of application is 11/4/2017. Now they stated that I'm past 9. I passed up to, of course, 9 to promoted to class 10. And this is not a recruitment, my lord. In the process of recruitment, class 10 is necessary. Plus,
paragraph 19 says what? When widow is appointed,
yes.
where widow is appointed on compassionate ground on grade 4, she will be exempted from the recruitment for the requirement of education qualification.
Yes, my
There is a provision is also there. Provided that
Where is the proviso?
there is no proviso on 19.
provided that required qualification, provided the duties of the position will satisfactorily be performed without having the educational qualification of middle standard or whatever prescribed in the recruitment law.
From where are you reading? Tell us.
Under the
Para 19.
Para 19 matter.
Provided the duties of the position will be satisfactorily performed without having the education qualification of middle standard or whatever prescribed. So the widow has, she was promoted to class 10.
Yes.
Promoted to class 10, but
Ah.
why not in the page number 29, all the selected candidates are class 10 pass.
Maybe.
Maybe.
But they have, according to the recruitment rules, they say, the provision.
No, then what will happen to this notification? Doesn't have any meaning. The notification, just like that, they'll publish.
So according to the provision, I.
No, this office memorandum provides that when a widow is to be appointed,
Yes.
the qualification will not come in the way, provided she is able to perform the duty.
Yes.
So where is the remarks in the recommendation saying that it's rejected because she cannot perform the duty?
Yes.
Anything like that? Only reason is under qualification. You are going by the recruitment rules. You are correct. You go by the recruitment rules. But when it comes to widow, in a compassionate appointment, office memorandum says that you cannot insist on the recruitment, on the qualification. So
But the government has selected a class 10 pass because they think that, think that they are capable of doing it. They fix the minimum qualification as class 10.
No, there is no hard and fast rule that minimum qualification is like that.
Look, another. also
In
case
another-
also, Tiwari case also for which. it- Because. it
which
was-
case?
They were also Tiwari. Okay. But, my lord, can I read this? Relevant data of this.
See, you come to your paragraph 4 of your counter affidavit. Page 27, I think,
Yes, madam.
counter affidavit, paragraph 4.
follow. It is there to the guidelines, government, office memorandum report, dated.
They haven't admitted.
According to the provincial
You are saying that you have strictly adhered to the office memorandum. If you have adhered to, then you have not considered paragraph 19, it seems.
can I read the judgment of the relevant para?
Where is the judgment? You give us a copy also.
I have. Same matter.
How many copies do you have?
I think,
How many copies do you have?
I have
Okay.
7.5 para.
Read
Read quick, read quick.
Supreme Court.
Yes, ma'am.
Yes, read. What is the what is the citation?
Considering of this.
From where did you get this?
State of West Bengal has reported the
Okay, but what is the citation? It is not reported or what? Where is it reported? In which?
appeal number stated.
Oh, civil appeal is appeal number. Is it reported in the journal?
Yes,
Supreme Court cases or anything like that?
is,
AIR?
it is a famous case matter.
Oh, it may be very famous case. So what? You tell me the journal, the citation.
Explanation, my lord, here it is only written 884 to 885. It is recent, my lord. Can I read this, my lord? 7.5.
Yes, read.
Considering this second question referred to above in the first instance regarding whether application for compensation requirement should be considered after delay of several years. We are of the view that in a case where for reasons of prolonged delay, either on the part of the applicant in claiming compensation requirement or the authorities in deciding such step, is diluted and lost. Further, the financial circumstances of the family of the deceased may have changed for the better since the time of the death of the government employee. In such circumstances, courts or other relevant authorities are to be guided by the fact that for such prolonged period of delay, the family of the deceased was able to sustain themselves most probably by availing gainful employment from others.
Okay. So the main thing is delay. Delay. Now come to your affidavit. Where
Yes.
in your affidavit did you state there is delay?
My lord, in another notification also government notification.
No, forget the other notification. You come to your affidavit. What is your stand? You are saying you complied with your office memorandum. That's all. But on looking at the office memorandum, you have not complied with.
My lord, here two petitions are linked. In first case, we filed this application. In the chapter, another petition was submitted.
Because I didn't know the rejection order. That's why I filed for rejection, challenging that
Where? Two petitions are linked means which case?
Petitions are for,
Your Lordship, I have
Yeah.
already submitted that. I have approached this honorable court earlier. Then they have filed
item number
affidavit.
7 and
And affidavit, they have stated that my case has been rejected. That's why I have again filed the case to challenge this, I need to say,
look here, item number 7.
district level selection committee.
Item number?
Item number 7 is
You have
6183
not to draw.
24 and another is 2932902.
Because earlier I didn't know that my case has been rejected. That's why, my lord. I have to challenge this rejection order, madam.
In the item number
Seven.
8. Item 8, what did you challenge?
Item number 8,
I'm challenging.
challenging that impure order.
What impugn order? Impugn order challenge kora nai. I have challenged to consider my case, my lord.
Please tell us.
Lordship kindly peruse the pair.
District to set aside the district level committee
Yes, that is-
minutes
that is
14,
section 1, 7, no? Rina Bolo.
14/11/2017.
Yes.
Where is it? Annex.
Reading the affidavit, I have come to know that my name is rejected under qualification. Then I again approached this honorable court to challenge this.
Okay.
Yes. Before that, I have filed several representation. In spite of that, I didn't know.
And in the first one, what did you challenge?
Which one?
In the first one, you have,
Lordship, can you peruse the pair portion? Appropriate directing the respondent to take immediate steps to consider the application of the petitioner, and petitioner is appointed against any available vacancy. That is
Okay.
my pair.
consideration.
Yeah, then they have filed affidavit. In affidavit, they have stated that, yes.
Yes, I've understood. So have you filed affidavit in the second one? What is your stand?
85% is taken.
Huh?
No, they did not file.
Then why do you say yes? Tell the court yes and you tell her no. What is this?
Second one, they did not file anything.
Second one, you did not file. You want to file?
What they will file, my lord? So they will say, stated same thing, my lord. Lordship kindly set aside the rejection order.
My lord, can I,
And they have put the another one also, the application which was inserted in wrongly. Because I applied 27/7/2016. They have put 14/7/2017, like that.
my lord, can I read a relevant para of compassionate family pension scheme? Yes, Act. The Act.
You're taking out your own papers, you're reading your own papers. We don't know what you're reading.
That
This
is,
is notification.
Notification maybe, but you have to give us a copy also. You're taking out some papers from your pocket and reading one after the other. What is this?
that is family pension notification.
But here also it is written that
But
the primary objective of the policy of compassionate employment has been to support the family income of the employee who dies in harness, who was the sole bread earner of the family as a stopgap pension. And if the family managed to sustain themselves for 3 years after the death of the employee, there was no ground for compassion.
it
It
is-
is clearly.
Ms. Devi,
yes, my lord.
where have you stated in your writ petition that you had no knowledge about the rejection of your application? Why I'm saying is that because rejection happened in
After
2017. You have filed a writ petition in 2024.
yes, yes. Because before that, I have filed several representation and I was annexed also for that representation.
No, tell me, when did you know that you have been rejected? Any statement?
They come to know the rejection after the filing of this.
Yes, ma'am. That is
When
correct.
we filed that affidavit. then
So
I-
you,
Then
so,
I have come to know.
so you also admit that
Yes.
she did not
Yes.
know.
Yes,
Then how can you say there's delay? Unless you communicate to the person, how will you say that there's delay?
delay means, my lord, that numerical figures to that it.
What numerical
Numerical
figures?
figures means the person concerned was.
And my lord,
state
in
or this,
for June Nessa also, it is Ashut Ranjan Das also, it is stated that,
See, person expired in 2016.
yes, ma'am.
Application was made in 2016. You considered in 2017.
17.
And
But
you
there
did,
is
you did
no
not communicate.
communicate. There is a provision. for
So,
communication.
The petitioner filed the writ petition in 2024. And in your counter affidavit, you say that, no, we have already rejected. You are to tell the court, show the court that you have already communicated, you are rejected.
Yes.
Then we'll consider your ground for delay.
He also giving permission that they communicate a lot of time. But
No, we did not. That
Yes,
is why
several
we have
represent-
approached this honorable court.
Presented several representations,
Yes, several representation have been filed, but they did not pay any heed to it.
but here on.
That is why we approached this honorable court, my lord.
but
And after
here-
filing the court, case, my lord, 2024, the limitation starts from them when they have filed affidavit, my lord.
My lord, we want to file a second, affidavit for this second.
No, you file, but I want to know also whether you communicated this or not.
They did not communicate it. That is why I got shocked, and then I have to, by forcefully, I have filed second case, my lord, because of that. And there is in Ashut Ranjan case also, it is stated that if respondent authority will reject the case, they should have been informed the concerned person, my lord.
Let delay
There is
on the
also-
part of, respondent or on the part of applicant is not considered according to the.
The Bogota theory's case is different, my lord. Facts also different. My case is different, my lord.
Delay is mentioned in,
I'm not in delay.
delay is explained in that.
And that too, recently also, Justice Honorable just passed an order recently, my lord, 2000. I think all the cases should be complete within a period of 15 or something like that.
This is BTC.
BTC, yes.
That one is, I think, state of Assam, state government.
The poor lady, my lord, she is a widow, my lord, having 4 children, won't be able to maintain their family, my lord. In spite of that, they are refused to provide the job, my lord. Whereas there is a provision for that, my lord.
No, see, there is also a point by the council. 2016 person died. You come in only in 2024.
24, because
Why?
several, no, my lord, I have mentioned in the earlier case. Earlier case I mentioned, and they did not, when the case was, did not mention anything about that in their affidavit. That she came earlier,
Me
I
Oh.
file annexer 20, page.
They have not mentioned, but I'm asking you.
6183, 2024 lawsuits. Kindly peruse, that is another case.
Where?
6183, 2024.
This is before me only.
Yes.
Where is your representation?
That is, lordship. Kindly see, 2016, I have filed representation,
Page number?
type copy, annexer annexer D, page 19. That is 27 July 2016. Then lordships,
Then,
19/8/2024. Nothing, they did not say anything, my lord, after filing the representation also. They should inform me that they have rejected my pair.
no. Page 19 is your application for the post of Chokidar.
Yes, ma'am.
Okay, thereafter, then what?
No, my lord, that is page the 24, 19/8/2024. Earlier also I filed, I did not annex here.
What happened between 2017 and 2024? No, 2016 and 2024.
Nothing happened, my lord. They did
Then-
not, if they have been rejected, they should inform me, my lord.
No,
Without information, there is a provision in Uchut.
maybe they didn't inform you, but what did you do on your part?
Then I have,
You did not do anything.
yes, my lord, of course. I have not.
2016,
mentioned her because
17, 18, 19, 20, 21, 22, 23, 24. 8 years. 8 years you were sitting tight.
There is, in Ashut Ranjan, there is a provision. It is written like that, that if a rejection order is there, they should have been informed to the petitioner. But they have not informed us. If they would have been informed me on 18, my lord.
No, you're right. They should inform you. But
Yes.
even if they don't inform you, you are also supposed to,
But Ashut
you are also supposed to come to the court within time.
They could have also approached.
My lord, everybody does not have any idea about court, my lord.
You got
Because-
idea. It took about 8, 9 years to have the idea to come to court. Cannot,
For it, Dylan.
But you tell me, did you communicate the rejection?
They did not mention that they have come in earlier case. They did not mention about the delay. Now he raised the question. Why, my lord? He raised the question now. He did not mention anything about in affidavit that she came earlier, the late.
Okay, anyway, let him get instructions. We'll take it up after the vacation.
And I have to file additional affidavit to annex all the repetition, man, because I have.
You have representations.
Yes.
Okay. List the matter again after the ensuing puja vacation. Petitioner is allowed to file an additional affidavit to incorporate the representations said to have been submitted by the petitioner for compassionate appointment. Stop. Mr. P. Mr. P. Hazarika, Learned Standing Council, BTC. P. Hazarika, Learned Council, appearing on behalf of Mr. S.R. Rabha, Standing Council, BTC, shall also obtain instructions as to whether the decision taken by the district level selection committee, Baksa district, why the meeting minutes dated 14/11/2017 was communicated to the petitioner at any point of time or not by the next date.
I should keep this matter as partner, my lord.
No, no. He'll come back again. List again. Okay, I've already said that.
Apply.
May it please the Lord. Matter pertains to compassionate appointment lordship. Petitioner approached earlier. Page 23, relevant page 23 lordship. Thereafter DLC recommended lordship.
Where did you approach earlier? Page 20.
Page 20, start from page 20.
Then
Relevant page 23, last para. Merit lordship.
not required. Then what happened?
Thereafter lordship DLC recommended.
Page?
Relevant page 33 lordship. Start from page 32. Page
Oh.
33 serial number 1 lordship.
Hmm.
Gulam Zakaria.
SLC.
Yes.
Then
Thereafter office memorandum has come lordship 18/9/2024.
24.
Yes.
20, it came in 24. The DLC was in 21.
Yes.
So about 3 years was there.
Matter is pending for the SLC last 3 years. Lord.
Then why did you come in 25? 2025.
In the meantime, office memorandum has come lordship. That's why.
Yes. Ms. Kaur, what do you say?
There was a delay of 19 years, Lordship. There
Hmm?
was a delay of 19 years, Lordship.
Delay of 19 years.
Yes, Lordship. The first petition was filed on 2002, Lordship. After that, it was recommended, it was placed before the DLC on 2021, Lordship.
So why didn't the DLC reject it on delay? They have not rejected. They have recommended.
And from the DC, Lordship, which I placed before your Lordship.
Hmm. What does it say?
Paragraph 3, Lordship. First page, paragraph 3, Lordship.
So you have not rejected the case on ground of delay. DLC has recommended. So why don't you complete the procedure then? Why should case of the petitioner not be directed to be placed before the SLC? Hmm? Hmm?
But now there is a notification came up for your, published by the Personal Department Logic of 38/2025, where there is a data sheet for filing all the pending cases lordship. I don't know whether the petitioner had submitted his application or.
Did you submit?
I have submitted on 10/9.
Huh?
Lordship. 10/9. 10/9/2025. I have submitted the required particular
Before whom?
before the Secretary Personnel Department. Lord.
Are you sure?
Not-
And what is that notice? Dated?
38/2025. Lord.
Notice dated?
38/2025.
And last date?
Last date on 15/9/2025.
So
I
we'll
filed this case on 3/6/2025.
dispose it off on that ground only. Heard, Mr.
And Hussain.
N. Hussain,
Yes, Lordship.
learned counsel for the petitioner, and Miss S. Gowar, learned government advocate for the respondents. Stop having regard to the nature of the grievance projected by the petitioner. The writ petition is taken up for disposal at this stage. Stop next para. The writ petitioner earlier approached this court by filing WPC number 6084 of 2002, which was disposed of.
24/9/2000.
Just a minute. I'll ask you if I want to require assistance.
Sorry,
Don't disturb. Which was disposed of by order dated 24/9/2002 by directing the respondent authorities to consider the case of the petitioner for compassionate appointment. Stop. The case of the petitioner's case was not considered for a long time, and it was only on 21/12/2021. I repeat, 21/12/2021, that the district level committee, South Salmara Mankachar, considered the petitioner's case and which decided to recommend the case of the petitioner before the SLC for considering his appointment on compassionate basis against available vacancy. Stop. Despite the recommendation, since the petitioner's case was not considered by the SLC, the petition is before this court. Next para. On 13/8/2025, the learned government advocate was asked to obtain instructions in this regard. And today she submits that as per the instructions received by her, the case of the petitioner was taken up for consideration by the DLC concerned. From the Secretary to the Government of Assam Personal Department. White memo number ADP stop 50/PT/415-A dated 14/12/2021, and also from the District Elementary Education Officer Dhubri. White memo number What is the memo number? Double ED, is it?
Yes.
Double ED dash 183/COMP slash 2015 dash 16/7112 dated 15/12/2021. Full stop. It is therefore seen that the petitioner's case was not rejected on account of delay, but was considered in terms of the instructions given by the government as well as the school education department through the district elementary education officer, Dubri. Stop. Next para. It is, however, seen that in the meantime, an office memorandum dated 18/9/2024 had been issued by the government of Assam in the Personnel B department, providing that compassionate appointment is henceforth stopped in view of the introduction of the Compassionate Family Pension Scheme. Stop. Agreed with the same. A number of similarly situated persons had approached this court, and this court invite a common order dated 3/4/2025. No. Okay, yes. 3/4/2025. And the lead case being WPC number 342 of 2025 disposed of the writ petitions by directing the respondent authorities to consider all pending cases for compassionate appointment as per the guidelines issued by the state government. Stop. Following the same, who had issued the notice? School education notice by
Personnel department.
following the same, the Personnel B department issued a notice dated 30/8/2025 requiring all persons seeking consideration for compassionate appointment to submit their particulars on or before 15/9/2025. Stop. The learned counsel for the petitioner submits that the petitioner had also submitted his application along with all requisites on 10/9/2025 before the secretary to the government of Assam Personal Department. Stop. Next para. Considering the above position, writ petition is disposed of by directing the respondent authorities concerned to consider the case of the petitioner through the SLC constituted in terms of the recommendation made by the DLC.
Plus,
Writ petition stands disposed of.
Wait, is wrong. No, in this case, the name of the petitioner were dropped from the UDAS court. And in their place, my lord, one of the private respondent number 7, his name may be the respondent number 6 tried to include his name, my lord, in the UDAS court against the name of the petitioner number 2. The case is that the petitioners were appointed in the pool of my lord,
How many petitioners?
2 petitioners.
Okay.
They were appointed one petition number 2008, and the petition number 2 was appointed on 13/9/2010 by the school managing committee in the Gwalbari Donipolo High School, North Lucknow, the district of Lucknow. They are working in the said school, my lord. Now the government is taking up the process, my lord, for provincialism test.
Now, why are you aggrieved with the inclusion of the name of respondent number 7?
My lord, by deleting our name from the UDAS code, my lord, the respondent number 7 was tried to be included in place of the respondent of petition number 2.
I see.
That is our grievance.
Any documents to that effect?
There is no documents, my lord, it could be placed before the honorable court, my lord. But the process is on, my lord, by the, at the behest of the respondent number 6, my lord. Headmaster. So, may I pray for issuance of notice at this moment, my lord.
Where are you working at?
My lord, in the Gwalbari Donipulu High School.
Well,
Our appointment order, my lord, page 23.
Lakhimpur district. Working as assistant teacher
As assistant teachers.
and teaching any particular subject.
Well, petitioner number 2 is a science teacher.
Who?
Petitioner number 2,
Two science. One is
the assistant teacher only, in arts, man. Petitioner number 1. In 9/2010,
14/9/2010.
page 23, man. Then except 2. And he has going on that day.
Petitioner number 2 is appointed on 13/9/2010.
Yes. And so for petitioner number 1 is concerned, page 22, serial number 6, date of appointment is there.
Okay, please write. Will issue notice?
School is a venture one.
Uh,
So there is a district tribunal in every district for the venture school, if you have any given. It's not a government school, Lord. Just to approach the education tribunal first, Lord, for the mitigation of that exam.
Tribunal under what provision?
Well, there are many cases disposed of by this honorable on the same issue, but the lordship kindly.
There's notification in a book. Where?
Application manual.
That
Yes.
is there, my lord. That
Yes,
is
it's
there.
there.
my lord.
What is the name of the tribunal? I mean,
Education tribunal in every district.
under what provision?
Notice, the notification is there, Lord.
Under what provision?
Provision I forgot. Wait.
It will be-
So you have an alternative remedy.
Yes, that is the only remedy for them, for venture school. Lord.
Well, there are many cases disposed of by this honorable court. I have all 4 cases. On the same issue. That was also on the same point, my lord.
Which one?
That notification of not is there. Lord. And this tribunal was constituted in terms of when there's a judgment in the Honorable Supreme Court Lordship in TMFI Lordship in 2012. So following the judgment Lordship, this process has been initiated.
You approach the tribunal
No, the-
within a
What happened, my lord, tribunal is, district judge is the tribunal, my lord.
Ah,
District judge is
Yes.
the tribunal. Already burdened with, my lord, many cases, my lord. No cases are taken up by the trial.
But
Tribunal.
after the
That
retrial-
is the problem, and that's why, my lord, writ petition has been disposed of on similar point. That is one case, my lord, I have 10 cases.
is it your case in the writ petition that although you
Same
have,
point, my lord.
no. Please listen to me first. Is it your case in the writ petition that although there's a remedy under the, to approach the tribunal, but since the tribunal is overburdened
Right.
and the petitioner, there is some urgency in the matter, that is why no alternative have come. Is it like that?
There's
then-
no environment is there.
So if no environment is then you approach the tribunal and
Well, it will
we'll
take
give you
the-
some protection. Perhaps we'll give you some protection also.
Ultimately, my lord, it will be futile, my lord.
Why do you say that it's
Tribunal
futile?
take much time, my lord. Already burdened with, my lord, criminal and civil cases by the district judge.
That
That
cannot
is
be a
why,
ground
it is
to oppose the
24
Honorable
meters.
High Court Lord.
That is why this honorable court was taking up matter on similar point. I have 10 to 15 cases with me. my lord.
Tomorrow, people will say Guwahati High Court is very overburdened.
That
We'll go directly to Supreme Court.
that is not,
Then
that is not the case.
what will the Supreme Court say? They'll send you back. Hey, go to the High Court.
My lord, they have not raised any point on this in this writ petition. Although the points are same, my. I can place 15 judgment with me, my, right now.
But that was,
They have
I
not
think there
placed.
should not have
They-
been
They have not objected, my lord. There is no government, no statement, no.
Your
submission.
judgment which you have produced, the print quality is very bad. You can't read actually. It's very faded.
I have many judgments on the same.
Uh,
I don't like to burden with your.
No, you don't burden me with such kind of printout because it's hardly legible. We cannot read. We are already wearing powerful specs.
Lordship may issue notice, my lord. This
Father, is a venture school notice, how can I read lie against it?
only notice.
There's already a provision regarding education tribunal notice.
It's better you go before the tribunal.
My lord, this honorable court has passed
No,
many
no, no.
judgments.
Maybe,
Honorable court has passed, but doesn't mean that in each and every court notice. that
maybe,
should be passed.
maybe. But seeing the
This
provision,
Pointed out before, that could have been pointed out by our.
They have not,
colleague.
my lord,
But
made
that
such
doesn't mean that
submission
we get
before his honorable
every
court.
time that will be passed.
It is the judgment, latest judgment, my lord, by Justice U.K. Nair, my lord. on- Judgment was passed on 22/1/2024
24.
on same issue. That is by the Justice, my lord, Michael Juthankoma, and one is my lord, Justice Devasis Purva, my lord.
those cases were,
Same point.
no, it was filed when? In the which year?
It was filed on
23.
24, my lord. This is 24, my lord.
24.
This is 21, my lord.
Oh.
Even 25 cases, 25.
What
the
was the decision?
Decision, my lord, the direction was given to the director to consider the case of the petition.
How can director consider the case of the petitioner or a venture school notice?
I have the copy.
Please write down the two petitioners have been claimed that they have been appointed as assistant teachers in the
Gwalbari,
Goalbari Doni
Doni,
Polo High School,
SR Pata, not.
S- which is said to be a venture school, on 10/1/2008 and 13/9/2010 respectively. It is their grievance that the process for provincialization of service is going on and the respondent authorities concerned, by deleting their names from the dice code,
Well,
have sought to provincialize the services of respondent number 7
seven.
instead. To stop, the petitioner number 1 is said to be an arts teacher, to be a science teacher. Mr. P.J. Saikia, learned counsel for the petitioners, submits that the impugn action of the respondent authorities concerned may be interfered with by this court by directing the consideration of the petitioners for provincialization of their service as per the relevant provisions of law. At this stage, Mr. SMT Chisti, learned standing counsel,
Second.
secondary education, has drawn the attention of this court to a notification dated 2/6/2016 issued by the government of Assam in the elementary education department under memo number ELC/WPC 2272/2013/403/196, which provides that which designates the Court of District Judge the Court of District Judges and additional district judges of each district to function as educational tribunals to adjudicate disputes of teaching and non-teaching staff of non-educational institutions. Including disputes relating to disciplinary action and claim for provincializations.
Yes.
Stop. He therefore submits that the petitioner has not exhausted the alternative remedy available as provided by the notification dated 2/6/2016. And therefore they should be relegated to the tribunal. Stop. This WPC is what? Supreme Court? WPC. Which case?
That is WPC, this is in the Honorable High Court law. Actually,
2272. This is High Court.
this is of Honorable High Court. This is
So?
what it is.
By which time you will go?
Well, my only prayer, my lord, prayer, my lord, time will taken by trial.
It may take time, but that will not be the reason.
Ultimately, the service, the petitioners will do, my lord, at risk.
How old is the petitioners?
My lord, they are 51 is 48 years
Huh?
old. 42 years old, my lord. There is no
They are still very young.
Finally,
go-
my lord,
you-
since this honorable court, my lord, has already disposed of many cases on same point. My lord. I'm placing all those records. The lordship may keep
No.
open the maintenance of the writ petition.
No, not like that. See, the if alternative remedy
My lord.
would be one of the reasonable point
Right.
to relegate you to that thing.
That's true. my lord.
What
but
may
cons-
entertain, may not
considering the-
entertain,
Right.
but I feel that you should go to the tribunal.
But
That is
normal-
why.
In normal, I've seen matter. I have picked all the copy, my lord, dispose of by the honor.
There's no whisper anywhere in your writ petition that you cannot go to the tribunal because there'll be delay and I'll be suffering. Nothing
I
like
can
that.
bring in my,
You straight away you're coming, so all cases will come to the High Court.
I can bring.
No,
That's
no.
why this court is also, my lord, entertaining the writ
Court
petition.
has the powers under 226, no doubt. But the existence of an alternative remedy would be one of the
Considering
one of the main
urgency,
ground.
my lord. Urgency is, my lord, there. When at any moment, my lord, the government may provincialize it too.
So that's why I also suggested that some protection can be given to you if you want to. If you don't want, well and good. Considering on the other hand, Mr. PJ Saikia Learned Counsel submits that the tribunals are already overburdened and it will take a long time for considering and adjudicating the case of the petitioner. Full stop. Petitioner, and therefore the matter may be taken up by this court. Full stop. However, it is seen that such an apprehension is not a case, is not the pleaded case of the petitioner in the writ petition. And delay in consideration, the delay in considering the case of the petitioner by the tribunal, it also cannot be the ground to insist on invoking the powers of this court under Article 226. When a tribunal has been provided for, specifically provided for, to consider and adjudicate the issues as raised by the present writ petitioners. Stop. In view of above, the petitioner may approach the tribunal concerned within a period of
10 days, 15 days, my lord. Ultimately, it will be in practice. Unless I. Okay.
15 days?
Well,
Which is the district?
Lakhimpur, my lord.
Within a period of 15 days. From today.
Some protection may be provided.
And until the petitioners approach the tribunal concerned within the stipulated time as provided herein above, the respondents, the official respondents are directed to maintain status quo. With regard to the provincialization of the teachers of the school, of the school concerned. Stop upon approaching the tribunal, the petitioners may seek appropriate interim orders if so required. And in the event of such prayer being made, the tribunal shall consider the same and pass appropriate orders in accordance with law. The petition stands disposal.
Apply. My lord, may kindly also observe, my lord, the tribunal should dispose of within a specific.
Hmm?
Tribunal should dispose of the, my lord.
No.
That cannot be teacher trial.
We don't know. You may not also file also. We don't know. You may go tomorrow to the division bench and say that single bench has rejected. We will not go that to the extent. You pray there.
Oblige.
Yes.
Me please, your lordship.
Yes.
Lordship, the brief facts of the case is that, your lordship, the petitioner has been working as an assistant teacher since the year 1988, your lordship.
Wow.
And in the year 2022, the Secondary Education Department, by its notification, has directed the in-service untrained teachers, your lordship, to pursue B.Ed degree through open distance learning mode via its listed universities, your lordship. Herein, the petitioner, your lordship, has successfully completed the B.Ed degree, your lordship, and the grievance is as such that he has not been entitled one advance increment as he is entitled to after successfully completion of the B.Ed degree, your lordship. Lordship, as per the last order, an additional affidavit has also been filed, your lordship.
You are seeking for advance increment
One advance increment.
because of B.Ed.
Yes, your lordship.
Is this in terms of what provision?
Lordship, if your lordship may kindly come to additional affidavits, page 38, your lordship.
38.
38 of additional affidavit, your lordship.
Yes.
Lordship, here is the office memorandum dated 7 March 1998, your lordship. Here it has been written that advance increments are granted to government servants of same cadres of different services under the state government as per Assam Service Revision of Pay Rules for requiring higher qualification, Government of Assam since 2188, that is the date of OM number dash, introduced procedure of furnishing option by the government servant to give effect to the advance increment either from the date of acquiring the higher degree or from the date of his next annual increment. In either case, however, the next increment would have to be granted after 12 calendar months of the grant of advance increment. And the next page, your lordship, since there has been no specific instruction regarding the date from which the advance increments will be granted in respect of cases prior to 2188, a number of references are made to the finance department on this issue. Government of Assam is pleased to order that for all such cases of sanction of advance increment for requiring higher qualification, such advance increment shall be sanctioned with effect date of next annual increment, irrespective of the date of acquiring higher qualification.
Means what?
Lordship,
Starting from which date?
starting from your lordship, as per this directive, they are entitled for one advance increment. And if your lordship may kindly come to next page, the page
No,
40, your lordship.
Advance increment will be from which date?
from, that is to be decided, your lordship.
It doesn't say that from the irrespective of the date of acquiring higher qualification.
Yes,
So would it mean that it would the date of this office memorandum? 7 March 1988, 98.
lordship, it means that after acquiring higher qualification, if representation is to be submitted after deciding that the higher increment would be
Have you
granted.
filed your representation?
Yes, your lordship, we have filed that.
Where is it?
That is in page 40, page 43 of this additional affidavit, your lordship. Lordship, there's a thing that we have filed our representations earlier, but it was not accepted. It was not been accepted. We have given that in the writ petition, we've written that in our submissions also in the pleadings, it's there, your lordship. And a press representation has also been filed, which has been accepted by the department. That is on 25th of July, your lordship. That is in page 43 of the additional affidavit.
Oh, just read the subject. What does it say?
Prayer for proposal verification, your lordship.
What is that?
That is that,
What verification?
lordship, we have clearly stated that in, it has been written to kindly, in the prayer, you have written that requesting you to kindly allow to drawing of one advance increment for successful completion of B.Ed degree course as per the Assam Service Authority Rules 2017, your lordship. We prayed for that and it has been forwarded by the principal of that very school, your lordship.
Can it not be disposed of?
Lordship, these cases are actually covered. We have also annexed one judgment of this honorable court. That is. Annexure I of the writ petition, your lordship, page 30. Page 30. That is the order we have annexed, your lord.
I've seen it. We'll dispose it of. Why? Why do you want notice? We are giving you, see, we are giving you liberty to verify and act upon the office memorandum. Are you saying this office memorandum is wrong? Then, the verification will be done in terms of the provisions given in the office memorandum. If they qualify, if he qualifies, give him the benefit. What is that? And already there's one representation pending. At Mr.
J.K. Roy, your lordship.
J.K. Roy, learned counsel for the petitioner, and Mr. T. P. Hazarika, learned counsel appearing on behalf of Mr. S.R. Rabha, standing counsel, BTC. Anyone else? No.
And if you respondent number
Also heard Ms. P. Das, learned standing counsel, secondary, correspondent number 2. And Ms. R.M. Barua, learned standing counsel, finance, for respondent number 5. Stop having regard to the nature of grievance projected by the petitioner. The writ petition is taken up for disposal at the motion stage itself. Stop. It is the case of the petitioner that he or she, he was appointed in the year 1988 to the post of assistant teacher. And during his service career, he has completed the B.Ed course successfully. What is ODL?
Lordship.
Distance learning.
Yes. Open distance learning. your
Through
lordship.
open distance learning mode. From the recognized university and as permitted by the respondent authorities. When did you complete?
Lordship, that is on, Lordship, the certificate was issued on 6 June 25, your lordship. For the December 24 examination, but the certificate was issued on 6 June 2025.
6/2. 6/2/25.
6 June 2025.
Where is that page?
Page 29 of the writ petition.
The petitioner was accordingly issued a provisional degree certificate on 6/6/2025. So according to the petitioner, the state government in the finance department, bracket establishment A, has issued an office memorandum dated 7/3/1998, by which an advance increment is permissible for teachers having acquired higher qualification.
Lordship, sorry to interrupt. Lordship, there is also another order of the Director of Secondary Education that is very recent of 2016, Your Lordship. Page 40 of the additional affidavit. Wherein it's also been directed for the same similar order. Your Lord. Page 40 of the additional.
The learned counsel also submits that the dated 21/7/2016 had informed all the inspector of schools what is this government notification 2210
Lordship. 2016,
at page 40.
page 40, Your Lordship. Yes, Your Lordship.
Government notification was set aside. What is this?
Lordship, that is what it is that, Your Lordship. In the year 2012, the Assam Secondary Education Provincialized Service Amendment Rules 2012 came into force, Your Lordship, which made it compulsory to have the minimum qualification for BA degree, Your Lordship. And at that stage, Your Lordship, another notification dated 229/2013-153 dated 2 October 2014, the government of Assam declared that the no advance increment for the degree of BA PT teachers for the teachers of secondary schools would be admissible, Your Lordship. This was challenged before this honorable court, and it was accordingly set aside. And after setting it aside, this very order was passed by the Office of the Director of
What's this?
Secondary
Just
Education.
read. Last line. That all assistant teachers are eligible to get one advance increment for acquiring B.Ed degree. In view of the decision of the High Court in WPC number 6241 of 2015, right order dated 16/2/2016, quashing the government notification dated 22/10/2014, by which grant of advance increment was stopped. The learned counsel also submits that further submits that the petitioner has submitted an application for grant of the advance increment to the inspector of schools, CDC, Kajal gown on 25/7/2025. But the same has not been considered till date. And for which reason the petition is before this court. The learned counsel submits that in a case of similar nature, this court had also directed
Thirty-one year.
31.
31 year. In 31 the order start of period petition.
This court also had also this court had also disposed of the case by directing the respondent authorities concerned to make necessary verification, and if it was found that the petitioners have acquired the required qualification, further appropriate steps be taken for grant of one advance increment. Stop in support of this submission. Reference to the order dated 12/5/2023, passed by this court in WPC number 2542 of 2023. Open bracket, Jitesh Biswas and 7 others versus State of Assam and 4 others. Close bracket has been referred. Full stop. Next para, having considered the above submissions and upon perusal of the materials available on record, the writ petition is disposed of by directing the. You'll file a fresh one? You file a fresh one before which authority? Let him file a fresh one before whom should you file?
Before the inspector of schools, your lordship. CDC. Kajal.
Again, inspector of school.
Your lordship. Respondent number 3.
Hmm?
Director of Education.
Why so much confusion? You're not sure.
I'm sure, your lordship. BTC. Director.
Where
of
BTC?
Yes.
So who should be authority? Tell me.
Lordship, the Director of Education, BTC, your lordship. That
Okay.
is the respondent number
The
3.
petitioner shall submit a fresh representation before the Director of Education, BTC, within bracket respondent number 3, within a period of 10 days from today, 15 days from today. And upon the petitioner submitting the representation, the respondent number 3 shall cause verification of the claim made by the petitioner. And if the petition is found to be indeed eligible to get one advance increment in terms of the standing guidelines of the government, the same shall be the benefit of the same shall be given to him. Such exercise be done and completed within a period of 2 months from the date of receipt of the representation.
DP, Lord.
Your lordship, also I am praying for a short accommodation to obtain instruction.
All right. Miss S. Quara,
Yes.
learned government advocate, no, learned,
Study council lordship,
learned standing counsel at secondary education,
elementary lordship.
elementary education. Praise board, how much time?
Immediately after vacation.
2 weeks time to obtain instructions in the matter. In view of above, list the matter after the ensuing.
Ablash.
That. Let's see, secondary KPS for response number 2. 201, 2. Correct.
My lord, petitioners are a school mother teacher. And their salary have not been paid since their joining.
How many cases do you have on mother teacher? You're a specialist in mother teacher.
One number I have here, I think he has 3 cases. Three, 4 cases. The other one is 3093 of the company.
What to do? Issue notice?
Yes,
Heard Mr.
arrest you.
R.S. Chauhan, learned counsel for the petitioner. Who submits that the petitioners are working as mother teacher. Which place? Where?
My lord, in various LP schools,
In various LP schools.
97, 98.
Since? Since which year?
97, 98.
The year 1997 and 1998. And by filing this writ petition, they have claimed for their area salaries, which have been denied to them. Issue notice, number returnable by 4 weeks. Stands moral and it. Your BTC.
I appear for,
Before that, you write Ms. D. Burman, learned senior government advocate, appears for respondent numbers 1, 2, on or respondent number 1, and Mr. Asbora.
I appear for now 4, 5 and 6.
SC BTC appears for respondent numbers 4, 5, 6. Elementary, RM Barua for respondent number 7. Name? Ms. Ende appears on behalf of Mr. Ardhar. SC. WPT and BC, correct? Anybody else remaining?
Yes, the 2 and 3. Education
Elementary,
is elementary.
let's go out for 2 and 3.
2 and
SC elementary.
2 and
Petitioner shall furnish requisite copies of the writ petition to all the learned counsels appearing for the respondents within 2 working days.
Obliged.
This is your lordship. Yes, your lordship, full process has been your lordship, state your lordship. It has been pending your lordship. In the meantime, your lordship, I may allow to obtain instruction in this regards, your lordship. So kindly short date may be given your lordship, after the opening of the date, your lordship. Any date may be given your lordship.
Notice was not issued.
Not
To be
yet,
issued.
your lordship.
Today's,
Instruction has been.
today speaks for the consideration of the interim also. Lordship may kindly record the statement that the whole process has been stayed. That may be recorded.
Due to numbers. of-
It's already recorded here.
Yes,
The
your
2-page order is already recorded,
lordship. Your
but notice is not issued.
lordship may
Will issue notice? Your good name?
M. Nirola Lordship.
Ard Miss M. Nirola, learned counsel for the petitioner. Issue notice on working returnable by 4 weeks. HP Das, SC, secondary education appears for respondent numbers
I'm appearing for 1, 2, 3 and 4.
1, 2, 3 and 4. Who else? Any other respondents?
No, your lordship. 1, 2,
Okay, all the
all
respondents.
the-
Have you got the copies, extra copies?
No, not yet.
Petitioner to furnish requisite extra copies of the writ petition to the learned SC, SP Das, SC secondary education within 2 working days. Should it be come up with the other case? Any other connected case?
There are Lordship, writ petition, WPC number 2610 of 25,
2, 6
10 of 25.
should be connected.
It may take.
List the matter again after 4 weeks along with WPC number 2610 of 2025.
Lordship, one Lordship, kindly the status quo may be made. Status quo. Okay. Though the recorded, the statement has been recorded, but the lordship stated provides. Till date,
Already,
no
your lordship,
appointment has
matter
been.
has been tagged, your lordship. It came along with the other, your lordship,
In the
petition.
connected writ petition also, lordship, there's a status quo has been granted. Lordship. Similar, I'm being with the similar.
The notices issued, your lordship, and that is, your lordship to obtain instruction. in this
There's
regard, your
already
lordship.
either
On the
process.
next date, your lordship.
No, court has already recorded that. Since as per the submissions of Mr. Kiski, the matter has already been stayed by the respondent authorities. There is no requirement for passing any imprimatur at this stage.
But on the last, the interim order will consider the date.
What interim do you want?
It is for lordship, but, because lordship, till date, no appointment has been made. Lordship, that much.
All right, status quo is on date, remain to. Till the next date of listing.
Second bit.
Yes, what is this matter?
May I please, as a lordship, my lord, regarding reduction in the grade pay from 8,700 to 6,800. Lord, in fact, few petition has already been disposed of. My lord, and one similar order I have annexed, my lord,
You are working as what? UP
working as a my
upper
lord,
primary?
assistant teacher, my lord, in high school, my lord. Initially, my lord, I was appointed as an assistant teacher in upper primary school. Later on, my lord, it had been amalgamated, and thereafter we have been paid, my lord, the enhanced pay of rupees 8,700 from rupees 6,800. Now, my lord, pursuant to
Amalgamated with what? High school?
amalgamated with high school.
With high school.
High school, my lord. Now, my lord, what has happened? Two incumbents has come up before this honorable court, my lord, with the prayer that they were not paid the enhanced pay of rupees 8,700. Their writ petition was dismissed. Then it matter went to the appellate forum, my lord, and the honorable division bench of this honorable court upheld the single judge's order. Now, as a result, what the department are doing, although, my lord, in that petition only 2 persons are there involved. They were even not been paid the enhanced pay. Now, my lord, by taking recourse of that division bench, honorable division bench order, a state-wise policy has been adopted by the state, my lord, that those persons who are receiving 8,700 rupees as an enhanced pay, their pay should be reduced to 6,800. So district-wise petition had been filed before this honorable court, my lord. And this honorable court, while my lord wanted to know the position, then my lord, the authorities in the, at the level of the inspector of schools at the various inspector, my lord, has, my lord, state the impugn arrangement that the, as the process which we have taken, my lord, was not in accordance with the finance department notification, my lord. If just for a moment, my lord, I have annexed a similar order, my lord, is at page 51, my lord, is the order starts, my lord.
Page
51, my lord, 51. My lord, what has happened? Initially, this honorable court wanted to, my lord, know from the my learned friend that what was the actual position at the district level, my lord. Then a letter had been communicated to my learned friend, my lord, that that letter had been reproduced in this order, my lord, is at page 53, my lord.
That is why lordship may kindly fix it after vacation also, it in the instruction regarding this case.
That can also
That is what-
be,
Lordship argued that.
because this order was not disposed on the very first day, my lord. After the instruction, this was, my lord, this
You are showing me page 51.
51.
What is the case here?
My lord, the case is similar, only this is pertaining to Morigaon district and the present petitioner is belongs to Nagaon district. my lord.
What was the decision?
My lord, the decision, there is no any judicial decision has been arrived into, my lord.
Then
But as the department has withdrawn the impugn arrangement, my lord, that's why this honorable court basing on that withdrawal order, my lord, this petition had been disposed of. by directing the authorities, my lord, that there is no live cause of action survive at that moment. So therefore, my lord, there is a direction to, my lord, release the salary as per the enhanced pay of rupees 8,700, my lord. And if any arrear was also due, that was also, my lord, direction was issued to release the same,
Reduction of pay was withdrawn.
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 So while Moriga this is concerned, it is from the Naga district. So we have to take instruction with that.
Mild.
Will issue notice, come with instructions.
My lord, can it be after the vacation, my lord, at the motion stage? my lord?
After vacation,
At the motion stage, why?
Motion stage.
Why?
Because this was also in the motion stage, it was
It
disposed.
can be disposed of any stage, at any stage.
Mild.
You
Mild.
want it to be disposed of specifically in a motion state. Why?
No, my lord, as my lordships, my lord, we have to go. by-
Heard Mr. R. Bhuya, learned counsel for the petitioners, who submits that petitioners are graduate teachers working in graduate teachers, and they were initially working in the upper primary schools. And later on the amalgamation of the primary school with the high school, they have been given pay of rupees 8,700. However, the same was arbitrarily reduced to rupees 6,800 without any signing, any reason, and without giving them opportunity. Hence, they are before this court. Referring to the order dated 23/5/2025, passed by this court in WPC number
My lord.
2676 of 2025, bracket annexure 6. The learned counsel submits that in respect of the similar situated teachers in the district of Morigaon, such impugn action was taken, but later on withdrawn by the authorities themselves. Stop. He submits that the instant writ petition also should be considered in the light of the said action taken by the respondents. Stop. In view of above, issue notice of motion returnable by co-weeks, Mr. SMT GST, learned standing counsel. Secondary. This will be what? Secondary.
secondary.
Accepts notice on behalf of all the respondents. Learned petitioners to serve requisite copies of the writ petition to the learned standing counsel within 2 days. On the next date, learned standing counsel shall obtain instructions with regard to the action taken by the state respondents.
All right. Lord, may I pray for a fixed date?
Fixed date. The date.
Well, obliged.
Yes.
My lord,
What
in
is
this
the
case, my
offence?
lord, an advertisement was issued for the filling of the post of the assistant teacher in upper primary school. my lord. In both Bengali and Hindi medium, my lord. In Bengali medium school, my lord. Instruction of is Bengali medium. my lord. So accordingly, I applied my being qualified, my lord.
Bengali medium.
Eh?
Bengali medium.
Bengali, my lord, the assistant teacher in Bengali medium as well as my lord for the Hindi teacher in Bengali medium. Because there are also provision for that also. The Hindi teacher in the Bengali medium school. my lord. Accordingly, this vacancy was also, my lord, worked out. If your now lordship will kindly see page, my lord.
But the school is upper primary school.
Upper primary school,
Okay.
in Kachar district. In Kachar district, lordship. Now, lordship will, if you lordship look to, kindly look into page 68, that is the, my lord, vacancy publication. That will clarify the thing, my lord will say.
68.
Page 68, lordship will kindly see. Page 60, lordship will, that is a vacant table 2, that is the vacancy position. Cut short, my lord. Now, Kachar district, lordship will find it. And
You're concerned with Kachar district only.
Kachar district only.
Yes.
Then my lord will see the page 60, it is, unreserved is 31 post now. If your lordship, first column.
Yes.
And if your lordship now look into the Hindi medium, page 71. Hindi medium, Bengali medium, Hindi teacher, upper primary school, page 71. In Kachar district, it is 18 months. It is 18.
Yes.
So, my lord, I applied, my lord. So accordingly, my lord, how the marks will be assigned to, my lord, that also envisages in the advertisement, my lord.
Hmm.
The advertisement was issued on 26/12/2023. I accordingly applied. Now, my lord will find how the marks will be ascertained, that my lord will find at page my lord 23, lordship. It is all, my lord. So page my lord 22, lordship will find category of post assistant teacher, upper primary school, 5% secured in the higher secondary school, higher secondary on equivalent examination, 5% from graduate from the UGC recognized university, or 5% from B.Ed and 80% from TET. Whatever the candidate secured in those examination, the marks will be taken in that percentage, my
And the last one says 5 marks maximum.
maximum, my lord. First 5 marks from the total marks secured in all these exams, my. So even except, my lord, that TET, Assam TET or Central TET. So whatever my marks I secured, they are 80% will be taken, my.
Yeah, then
So by my going by this calculation, lordship, I have applied, I category also stated, my lord, that I secured, my lord, 60, my lord, I secured 66.247%,
according to you.
according to me, my lord, going by this calculation, my.
Oh, then
And now, if your lordship now take into the provisional merit list, my lord, that lordship will find at page 44. Start from, sorry, my lord, page 47. 47. Start from page 47. Now, lordship will find that is, my lord, undeserved assistant teacher, upper primary school, page 54. Lordship has got it.
which
54. There, that is their provisional merit list, first provisional merit list. That is undeserved category. I belongs to undeserved category.
yeah, 54.
Yes, my lord has got it.
Hmm.
Now, my lord, the highest is 78.81. Lord.
Hmm.
Then, my lord, lowest, my lord, there is 31 post, as I have just pointed out to your lordship as per that vacancy position. The lowest is, my lord, 65.17. That is at page 57.
Hmm.
And I have
65,
66 point something, my.
65.171.
Yes. So I'm above that now, because I got 60. 66.714. Now, my lord, if your lordship now look into page 60, that is, my lord, will find that Hindi teacher in upper primary school.
Which
Page 60 million.
60.
60 million.
Yeah.
My lord, it start with, my lord, 61.706 and ended with, my lord, page 62.
This is
my
this
lord,
is in respect of Hindi teacher in
Hindi teacher in upper primary school.
the other one which you showed me. What was that?
Is an assistant teacher in upper primary school.
Okay, assistant teacher.
It's assistant teacher.
Assistant teacher, but in Hindi.
In
In Hindi.
yes, please.
Assistant teacher in Hindi. Or assistant teacher general.
General.
I
It's
see.
include Hindi, everything, man. Because in Bengali medium school, there is a provision for Hindi teacher also, man. They can teach in this medium.
You applied
also.
for both.
Yes, yes. Yes.
You applied for the assistant teacher in general.
Both. Assistant teacher, upper primary, assistant teacher, Hindi.
Yes.
Now, my lord.
In Hindi, the maximum is what? 61
maximum
point
is 61.706 mile at page 60 mile.
and minimum is
Minimum 56.839 mile.
Where is that minimum?
Minimum lordship will find it
Page?
page 62 million. 62 page 56.83.
Hmm.
So my lord, in both the cases, my lord, I am above the lowest one. But despite of that, my name did not appear. Therefore, for verification of my testimonial, I appeared.
What is the current,
Current
Status.
status, my lord, there only provisional list has been published, my lord, but they may soon, huh? Oh, this is it. Oh. As per instruction, my lord, for 10th October, final list will be published, lord. So they may obtain instruction in between. Huh?
Your lordship, so, and if Perusa page 64. ma'am.
hmm. 64, yeah.
64, my lord, the bottom, my lord. Our case is, my lord, now, my lord, there are three major, my lord. In bottom, my lord, clearly stated that any claim for appointment to the post of teacher on the basis of mere appearance of name of provisional merit list will not be entertained. Second, my lord, appointment letter will be issued only to the candidate whose name appear in the final selected to be published in due course of time.
What is this list then?
What is
This
this?
is provisional list, my lord.
Provisional merit list.
So,
So provisional list name is not there.
Yes, my lord, that is an agreement.
Then there are chances of
Yes.
name appearing in the final list.
maybe, my, maybe.
That's how maybe, my lord.
Uh,
You keep one post vacant.
Yes, my lord.
You come up with instructions, we'll
Yes.
see.
Yeah.
If the claim is not correct, then
Yeah.
the matter will go.
so
Yes.
we may pick on tomorrow, my lord, in the paper.
Tomorrow.
As far as his information, my lord,
Immediately, vacation one goes.
or immediately.
Yeah.
You want it tomorrow? Let's have it after the vacation.
Yes, my lord.
Heart Mr.
BJP.
PJ Ghosh, Learned Counsel for the petitioner, who submits that the petitioner has applied for the post of assistant teacher in the upper primary school, as well as Hindi teacher in the upper primary school
Yes.
in the Bengali medium.
Yes.
Stuff he submits that as per the marks or weightage to be given
Yes, please.
to the applicants.
Yes.
In terms of paragraph 15 of the advertisement dated 26/12/2023, bracket annexure 1. The petitioner has assessed himself or herself,
Yes.
himself,
Herself.
assessed herself
Yes.
to be securing 66.247 marks.
Yes.
Stop. However, her name has not been her name does not appear in the provisional select list.
Published on 10/9/25.
Published on 10/9/2025.
25.
Stop. The Learned Counsel submits that going by the provisional list
Yes.
of assistant teacher in upper primary school and assistant teacher in the subject of Hindi in Bengali medium, the petitioner has scored more marks than the last candidate shown in the list. And therefore, the petitioner being aggrieved is before this court. Next para, issue notice of motion returnable by 4 weeks. Mr. B. Talukdar, Lanet,
Elementary, my lord.
SC Elementary,
1 and 2.
SC Elementary, accepts notice on behalf of husband 1 and 2. And Mr. I. Alam, SC NCT, accept notice on behalf of respondent number 3. Notice is therefore complete. Petitioner to serve requisite copies of the writ petition to the learned counsels paying for the respondents within 2 days. List the matter again on 2310. Till the next returnable date, the respondent are directed to keep 1 post of assistant teacher vacant.
No, no, my lord.
If you, depending on the instructions, we see, we might vacate also.
Dependent on them.
Huh?
Instead of keeping a 1 post vacant.
Why?
Because if you control second person, it will create process second.
That is a provisional, my lord. They will get it final by this time.
This is not a final list.
Yeah, yeah.
And tomorrow.
Okay, last line, you, what did I say? No, first thing, returnable by tomorrow date. Then last line. That you can list again tomorrow. Huh? Respondents to the learned counsel for the respondents to obtain instructions by them. Yes.
Hey, please. Matter relating to excess dwell excess dwell payment due to wrong fixation of pay matter. You will find the case 32, my lord. This is the letter of the pension.
When did you retire?
My lord, I have retired in 2022, my lord. This is currently covered in the judgment of the apex court of big measurement as your lordships as dispose of the same case, my lord.
Yes, what you say? Recovery already done,
No, my lord, recovery
not yet.
not been done, my lord. Due to, my lord, pension has not been analyzed due to excess.
Pension has not been given.
Yes, my lord. So, my lord, this is this, your lordship will find the case 44, my lord, similar order. Your lordship will find, pass the order.
Heard Mr. R. Islam, learned counsel for the petitioner, who submits that the petitioner retired on 29/2/2020. From a grade 4 post. Grade 4 post
Yes, ma'am.
in Mahesh Chandra Academy High School. Dumar Daha in the district of Dhubri. And despite the same, no pension benefits have been given to him till date. The learned counsel submits that the respondent authorities concerned on account of alleged excess drawal of rupees 379,028 due to wrong fixation of pay
Yes, wrong.
is contemplating recovery of the same from the petitioner. And the same has also resulted in the holding up of the pension benefits of the petitioner. Of the learned counsel submits that the law is well settled in this regard as held by the apex court in the case of State of Punjab and others versus Rafiq Masih bracket whitewasher and others 2015 for SCC 334. Stop. He also submits that in a case of similar nature, this court white order dated 12/8/2025 in WPC number 2453 of 2024. Open bracket. Jhanara Abedin versus State of Assam and 6 others. Close bracket. Had and interfered with the recovery process. And directed finalization of the pension of the petitioner therein. Stop. He therefore submits that a similar order may be passed in the instant writ petition. Next, para in view of above, issue notice of motion returnable by so and so. Miss P. Das, Lanet,
1, 3, and 5.
SC secondary, accepts notice on behalf of respondents 1, 3, and 5. Miss R. M. Das, Lanet for SC finance for respondent numbers 2. And who else? State Miss
Pension is also there, Your Lordship.
D.D. Burman for respondent numbers 1 and 4. Notice is therefore complete. Petitioner to serve extra copies within 2 days.
Pendency shall not be barred to finalize the pension.
All right, pendency shall not be a bar for the respondents to finalize and accord the pension and other benefits to the petitioner.
Obliged.
I'm deeply also.
Yeah, please, your lot. Your lot. Yes, yes, sir. Lordship, is the case regarding the appointment of principal. Principal have been appointed, that is the respondent number 4. He has been appointed on 31/2023. And here the petitioner has been aggrieved here. Your Lordship, here as per the page number 26, Your Lordship, that is the seniority list. Where's the order appointing the private respondent? 30. 30. Already appointed here. He's already have joined in the month of February. Page 30. 30. Order dated 30th January 2025. We'll issue notice, Hart Mr. Peter. B. Deb, learned counsel for the petitioner, who submits that the petitioner is aggrieved with the order dated 31/2025 bracket annexure L, by which the private respondent number 4 has been selected. Appointed to the post of principal of Grahampur Higher Secondary School in the Kokrajhar district. Despite being junior to the petitioner, issue notice of motion returnable by 4 weeks. As Bora. I pay for note 2 and 3. Correspondent numbers 2 and 3. SC BTC, okay? 2 and 3. Vidas SC secondary for 1. Petitioner to take steps for us. Serving notice to respondent number 4 by registered post with AD within 3 working days. Extra copies of the writ petition will serve to we furnished to the learned counsels appearing for the respondents within 2 days.
Petitioner appointment, my lord. A father of the petitioner, my lord, he was
Bench three.
Yes.
Constable, Director of Civil Defense and Commandant General.
yes, my lord.
Okay.
He was found missing, my lord.
Uh,
Lord, can it be tomorrow, my lord?
it is submitted to the bar that the matter pertains to bench three. Registry to verify and list the matter before the appropriate bench tomorrow. Give the date
Public.
on so and so.
Lordship, this is a review application preferred by the state of Assam. There has been delay in preparing the review, which was filed in the month of June 2025 of a judgment of 2016. And earlier, the Lordship was pleased to ask us to explain the delay. An additional affidavit has been filed. In fact, this judgment was never received by us till a contempt notice was received by the present secretary sometime on 6th of May 2024. And this writ petition, along with the other cases in the batches of cases, these were all tagged together from 2018 to 2022. In paragraph 2 and paragraph 2 of the additional affidavit, we have stated. So my humble submission at this is let the notice be issued. If the other side objects also, then Lordship will definitely hear the other side also. And the other ground is that main review on the basis of two judgments, one of the Supreme Court and one of the Division Bench of this Honorable Court. A person was working for 24 years, so he is entitled for salary. That was the ground. But in our affidavit plus as well as all the records shows that his original appointment was totally fraud. He was considered to be working in a school which is non-existent. He was working in place of a vacancy against a person. There is no such name. All these things are part of the affidavit which Lordship will find at page.
Affidavit in the writ petition.
In the writ petition. All these facts were not considered by the Honorable Court. At this place, facts were placed, the order would not have been passed. The blatant forgery. A fraud has been played. If Lordship is pleased to look at page 139 for a moment.
139.
139. These are part of the affidavit in the original writ proceedings. May I read it? Paragraph
Yes.
7.
Yes.
That the deponent begs to state that the District Elementary Education Officer Dhemaji, referred to as DO Dhemaji, informed the directorate that as per the report of the Block Elementary Education Officer Borduloni Dhemaji, there is no government provincialized LP school in the name of Ming Mang LP school either in Dhemaji or in Lakhimpur district, and therefore the question of expiry or retirement of one Buddheswar Pegu from the said Ming Mang LP school prior to December 2029 does not arise. It is apparent that the appointment order of the petitioner dated 5/12/1989 and the then Deputy Inspector of Schools Dhemaji appointed the petitioner as an assistant in Arandhai Milan Nagar LP school in the pay scale of 470 to 800 per month against existing vacancy at Mingmang LP school by Buddheswar Pegu expired retired. The petitioner also did not mention that he was transferred from Arundhai Milan LP school to Gyanudoy LP school. So whole thing, the whole basis is fraud. So these kind of things, Lordship, when it has come to our knowledge, it is our duty to place before this Honorable Court. Therefore, we have filed this review application. Paragraph 8 gives more details. So, and on top of that, when he was considered to be as a government, his age was found to be 16 years only.
No, you say that this copy of the judgment was not given to you.
Which does not, no, it was not given to us.
Where's the statement to that? effect?
Yes. That
paragraph 2 of the additional affidavit. Additional affidavit. That the present additional affidavit has been filed to explain the delay in filing the review. In this regard, it is stated that although the original order was passed on 31/10/2016 in WPT 20, there is no record of the said order having been communicated to the department at the government level. As a result, the department remained unaware of the said order. Upon perusal of the available record, it is seen that between 2018 to 2022, the matter was clubbed with several other writ petitions and contempt proceedings, and no distinct or specific order was passed in respect of the contempt involving the petition. Those cases are in the High Court, Lordship. Consequently, the case of the writ petition did not come to the notice of the department during the said period. The matter was first brought to the attention of the department only when a contempt notice in case number 520 of the 2016 received on 19/4/2024. Wherein the present Secretary of the Department has been implemented as the contempt number 4. Upon receiving the said contempt notice, the Director of Elementary Education by letter dated 6/5/2024 was requested to furnish a status report in the matter. The
Okay.
Director of Elementary Education on 17/5/2024 submitted an inquiry report pertaining to appointment of the and the findings regarding the appointment.
Will issue notice at this
Yes.
stage.
In
Now,
both the-
why this Tarun Chandra Bora is by name, District Elementary Education Officer? In the writ petition also was by name,
in the writ petition
by name.
by name.
Please write, Mr. D. Saikia, Learned Advocate General, Assam, assisted by Mr. N.J. Satania, for the petitioner, who submits that by filing this review petition, the petitioner seeks review of the order dated 31/3/2016, passed by this court in WPC number 2276 of 2011. Stop. The Learned Advocate General submits that since there has been some delay in filing the review petition, the petitioner has filed an additional affidavit explaining the reasons for the delay. In view of above, issue notice returnable by 4 weeks. And the petitioner to take steps for service of notice upon the respondent. Number. On the respondents, isn't it? Both. What will happen number 2? What will happen to number 2? 2 may not be the officer anymore also.
Only Muhim for. Only Muhim.
On respondent number 1. By registered post as well as by usual service.
No.
Within 3 working days. List again after 4 weeks.
Deeply open.
What is this matter?
Your lordship, this is relating to your lordship. Your lordship may kindly see the peruse the last order. Your lordship has recorded my submission. Lords. In nutshell is this, your lordship, we have filed a writ petition, your lordship. During pendency of that particular writ petition, your lordship, an advertisement was issued, your lordship. This honorable court allows us to participate, your lordship, in an interlocutory application. We participated, your lordship. And in the meanwhile, your lordship, the honorable court was pleased to hear the entire matter and held that the respondent authority cannot insist on the Hindi subject as a part of the graduation, your lordship, degree.
It's about Thakur that I've understood.
Lord.
I've read it.
Lord.
So why is it fixed today?
That is your lordship for their submission, your lordship, probably.
I see.
I have received some instructions.
No.
Let the matter be taken upon the reopening date 13.
By that time, your lordship, appointment will be made, your lordship. Ultimately, your lordship, there is a order, your lordship, which says, your lordship, that we are eligible, your lordship, even if that they have not considered us, your lordship.
What is to be done?
Your lordship, my
They will be
prayer is that
considered. They are part of the recruitment process. Now everything will depend upon the merit. If they are getting more higher marks, then they will definitely get. They are already there.
No, but I think the issue was also regarding the Praveen. Hindi
no,
Praveen.
not Proveen, your lordship. So far as my case is concerned, there is no
There's no issue on Praveen.
Proveen, your lordship. That is why they have issued a letter, your notification, your lordship. Will kindly come to page 80. Your lordship has referred to that. They have filed a affidavit in open.
Page 18. 18.
Page 80
Where?
of the their affidavit in opposition.
This is what IA or?
Main
This
case,
IA.
your lord. Affidavit has been filed.
Page 18.
Page 80. Annexure
Annexure?
A. Page 80, your lord. It was there, your lord. In their affidavit in opposition. Your lord.
No, it's not there.
WPC number 4550.
Page 18. 18.
80.
Oh, 80.
80, your-
0. Yes. Yes. So what about this?
This, your lordship, issued on 9th, your lordship. And my case is that, your lordship, since
Your exams were before that.
that
before
before
this.
prior to that, your lordship.
Okay.
In 2023, advertisement was issued, your lordship. In 2023 itself, honorable court allowed us to participate, your lordship.
Mr. Saikia, you want it after the vacation?
Yes,
But-
I'm not very clear about the fact, but my learned friend is very clear about the fact.
But what about the protection to them?
Any appointment will subject to outcome of
Hmm.
this.
That, your lordship, ultimately, what we are praying, your lordship, at
And
least.
that notification has been issued in terms of the direction of this.
I understand. But the thing is that if we have that kind of order, then whoever has been promoted, supposing he will have to challenge them again.
that is
26, how many? 23 or 26?
26, your lordship.
26 people will have to be brought in record and challenged.
Lord. That's the
What to
problem.
do?
26 posts may be kept reserved only Hindi, your lordship. Others they can, your lord.
Keep 26 people. Mr. D. Saikia, learned advocate general, submits that the state respondents would like to file their affidavit in opposition and that instructions have already been received. He prays for 2 weeks' time to file the affidavit in view of our list this matter again on 1310.
It will be on 14th. That you did.
14.
1410. Affidavit be filed on or before the next court date with a copy in advance to the other side. Meanwhile, the respondents are directed not to keep how many posts? 26. 27.
26, your lord.
26 posts of
Hindi teachers, your lord,
Hindi teachers
in upper primary school.
in upper primary school in terms of the sought to be filled up in terms of the advertisement.
Dated 27/12/2023.
27/12/2023 vacant till the next date.
Deeply approved.
For delivery of order item 1, bail application 35 of 25 pertaining to Aizol Bank.
Yes, can you hear me?
Yes.
Okay. I have dictated the order already. So the bail is allowed.
Yes.
Bail is granted, but there are certain directives also to be followed by the DGP and others. So this, I'll not read it out. Once you get the copy, you'll find it. I'll send later on.
Item 2, bail application 39 of 25, 2025.
Yes, Mr. Faxwala
My
and
lord,
learned additional PP, I have allowed the bail.
I'm obliged, my lord.
I have allowed the bail. Certain conditions are there and some directives are there also to the state also.
Obliged, my lord.
Obliged.
For orders item 3,
Yes, Milos, I appear for the applicant here, Milos.
Yes.
I am seeking a Milos modification, a clarification of the order, Milos, in view of the subsequent developments which has taken place inter se between the parties, post my lord's passing an order on 8th of March 2024, Milos. So this is my application, Milos, under section 151 of the CPC. On behalf of the applicant, which is the government authorities, Milots, entities, for modification of the order, passed in the writ petition, Milots, by my lords. So I can just straightway take my lords to the operative part of the order before I give my lords a little background on the factual aspect. So if my lords has page 40 of my application.
Page 40, yes.
Yes, my lords has. This is my
Yes.
lords order dated 8th March 2024.
Mm.
Para 19, if I may be permitted to read, Milots.
Yes.
Milots, it says, therefore, under the fact and circumstances, considering the dispute raised by the parties, the pendency of the arbitration proceeding, and also the interest of the parties concerned, this court is of the considered view that the writ petition cannot be allowed as prayed for, and instead it is hereby directed that the amount due to be released as retention money by the employer should be kept in a fixed deposit in a nationalized bank renewable periodically by the employer. The amount so deposited, along with the interest accrued therefrom, shall be payable to the parties concerned in terms of the decision to be arrived at by the arbitral tribunal. So I'll give a little background, Milas. After this order, what has happened is, Milas, the dispute between the opposite party 1 and 2, that was award, Milas. There was an arbitration which was ongoing during the pendency of this writ petition, Milas. And my lord said, till the time the award is not pronounced, this money may be kept in a fixed deposit by me. That is the applicant here, Milas.
Arbitration was between which party?
Opposite party number 1 and 2, Milas. The subcontractor and the subcontractor, Milas.
Opposite party number 1
and 2.
And 2.
Yes, Milas.
JKM Infra Project and APS.
Yes, Milas.
And the application today is filed by
the government, PWD.
The state.
Yes, state, Milas.
Okay.
So, Milas, after this order, Milas, after my lord's order, the arbitration, they have arrived at a settlement, Milas, on 14th of May 2025, Milas. They have entered into a settlement saying this is the amount of money which has to be gone to this APS, and this is the amount of money which has to be released to the JK. Now, Milas, pursuant to the award, APS, the opposite party number 2, has sent me a letter which I have for releasing 75% of the retention money in terms of the award. And as there is no dispute with APS, the opposite party number 2, I have released the money, Milas. if my lord also will be kind enough to see at page
No, first of all, where is the settlement?
settlement, Milos, I'll take my lords to settlement. I'll take
14/5/2025, you say?
page 42 if my lord has it. Page
42.
42. An extra 2, Milos, page 42.
Yes.
If my lords can turn over the page and come to page 45, Milos.
45.
Yes, Milos. So now this agreement, if my lords can come to the
Yes.
bottom of the page,
Mm.
it says division of retention money with authority and insurance money, Milos.
Mm.
This is the division that they have done. I'm a little surprised what kind of settlement this I'll, as and when need arise, Milos, I'll submit. So these are the terms of the settlement, Milos. So if I can, I may be permitted to read para 1 of the settlement, Milos. Can I read, Milos?
Yes, yes.
It says the parties agreed that the retention money due from the authority and which is lying with the authority and deposited in the fixed deposit in the bank as per the direction of the Guwahati High Court Aizol bench dated 8th March 2024 in case number represents so and so title JKM Infra Limited versus State of Mizoram and others shall be divided between the parties in the ratio of 25:75. That is, JKM to be entitled to 25% of retention money lying in the deposit as on the date of withdrawal, and APS would be entitled to 75%. So 75% of the so Milos, APS pursuant to this award sent a letter to me, which is on page 53, Milos.
Mm.
If my loss can come to, this is the award, Milos. This is the award. So APS sent me a letter, which is on page 58. If my loss can come to for a minute on page 50, Milos. 50, Milos, my apology. Page 50, Milos.
Mm.
This is the letter for requesting the state to release the retention money, Milos. My loss has it?
Yes.
So it's
75%.
Yes, Milos, 75%.
This has been released.
This has been released because there's no
Now,
dispute. Yeah.
Okay.
And
What
Milos,
about the 25%?
I'll come to that, Milos. I'll come to that. So Milos now can come to page 53, Milos, which I wanted to show.
$53, yes.
He says undertaking the regarding. So Milos, with APS, there is no dispute of the state, Milos. So they have said in the end, Milos, we hereby acknowledge the best and true so and so. We hereby, point number 2, Milos, that we hereby unconditionally and irrevocably undertake that APS Hydro will not submit any claim with PIO, PWD, Mizoram or its office in respect to the aforementioned execution of the work. So there was no dispute with APS, Milos. So we have released the 25%, Milos. With regard to Milos, with regard to the JKM, the main contractor, he's a subcontractor, Milos.
APS is 25.
Yes.
APS you've released 25%.
No, 75%, 75%.
Oh, 75.
So APS, basically APS who was a subcontractor, Milos, who did everything right from inception till the completion of the work. The award was given to JKM, but he subcontracted everything, Milos.
APS.
Yes.
APS is the actual thing firm which undertook the.
Yes, Milos.
And 75% has been released to them.
Absolutely. Yes, Milos. Now, Milos, after the order of my lords, JKM, the opposite party number 1, the main contractor to whom the award was given, they have invoked an arbitration against me. That's very important, Milos.
They have invoked?
No. They have invoked an arbitration under the contract, Milos, on 17 September 2024.
Okay.
And they have lodged a claim of 300 crore, Milos. Milos, with due respect, is a design defraud on the State Department, Milos. Having done nothing, not as one stretch of kilometer, now they have invoked an arbitration, and the interstate settlement also is such, Milos, where there was a claim of the subcontractor on the contractor for 200 crore. Now they have even divided the retention money. It's basically siphoning of the funds of the state, my lord. So my lord says page 54. If my lord says page 54, this is the statement of claim, my lord, filed by the JKM against the PWD state, my lord. My lord has it, page 54, my lord.
Yes.
This is the
54.
statement of claim. Yes, my lord.
Annexure 5.
Annexure 5, yes, my lord. So this is the statement of claim filed by the JKM, to whom 25% was supposed to go, my lord. So, and on the next page, if my lord comes on page 56, they have claimed an amount of 292 crore, my lord, an odd amount. If my lord says the prayer at 147.1, has my lord got that? Page 56?
Yes.
Page 56, my lord, prayer E is the prayer, and para number 147.1 basically lists out the award amount. They further revise the claim, my lord. They further revise the claim, which is on the next page, my lord, on page 58. And if my lords can come to page, internal page 60, my lord, next page. Running page is 60, my lord, internal page 57. Now they are claiming 377 crore, my lord. I hope I'm clear, my lord. So this is their revised claim against PWD, my lord.
Yes. What basis of the claim?
Miller's claim is prolongation, delay, everything. After the subcontractor having given me under, sorry, it's basically Miller's, that's where I needed to explain to my lords. That subcontractor who has executed the work has not made any allegation of delay, prolongation, or anything, Miller's, or negligence, or breach of any terms of the contract. Whereas the contractor who did not even execute 1 kilometer, Milos, now on account of delay, latches, and breach of the various terms of the contractors, has now raised a claim of 377 Milos on me. And Milos, I have a counterclaim because during the defect liability period, I had to complete certain work, which amounted, and I have filed a counterclaim because under 36.1 Milos, there is a defect in the which needs to be corrected by the contractor and the subcontractor.
Defect
So
liability
defects,
period.
Milos, in the roads, which they had executed, but they did not complete the defect or rectify the defect. Therefore, I had to apply additional resources, float new tender for getting the work done to rectify the defect, Milos. So I have filed a counterclaim, which is on page 62, Milos, in excess.
See, Mr. Roy, Mr. Roy.
Yes.
Why have you filed the IA? Come to the point.
The only thing, Milos, that this 25% money, Milos, which has to be supposed to be released to the opposite party number 1, JKM, should be kept in a fixed deposit, Milos, till the pendency of this arbitration. That is the short prayer I'm making.
How can we do that?
Milos,
how is that possible?
No, it is a dispute, Milos. It's a dispute because there was no dispute.
No, this dispute is not before this court.
No, Milos, because my
the dispute is not before this court.
Yes, Milos. No, Milos, Milos, this is now.
No, we had passed an order.
Yes, Milos.
Just a minute, Mr. Counsel, Mr. Roy, just a minute.
Yes, yes,
the dispute which you had come up with in the High Court,
yes, Milos,
or the dispute WPC 80 of 2022,
yes, Milos,
was disposed of on the premise that there was an arbitration pending,
yes, Milos,
before JKM and APS.
Right, Milos.
So, as regards that, what do you call that money?
Yeah. Retention money, Milos.
Retention money.
Yes, Milos.
Court said that none of the party will have it.
Yes, Milos.
But whatever the arbiter tribunal decides,
right, Milos,
depending on that, depending on the direction given by the arbiter tribunal,
right, Milos,
the money will go to that.
Absolutely, Milos. Absolutely.
So,
Milos, even the arbitration, that JKM and APS arbitration was not before my laws. That time, my lord is
Correct.
recorded in para 16, Milas. So I'm saying, Milas, the situation remains the same. Today, there is a dispute between JKM and the state, Milas, because they have raised an invoked an arbitration against me, and I have a counterclaim, Milas. If I give the money today, Milas, and if I succeed in my counterclaim, which is 100%, Milas, tomorrow I'll be left high and dry, Milas. I'm only requesting this money may be kept in a fixed deposit till
No,
the
no, see, I understand what you're saying, but the thing
Yes,
is
Milas.
that
Yeah.
the issue is not before this court no longer.
Yeah.
The issue is not before this court at this
Right.
stage.
Right, Milas.
Now you are in arbitration with the other party.
Right, Milas.
You can very well take up the matter with the arbitration tribunal
Right, Milas.
with regard to the keeping the money in a deposit.
No, Milas, this is direction passed by that the previous Milas, the previous tribunal, Milas. This tribunal cannot pass that order.
Hmm?
This tribunal cannot pass the order because this order has been passed by the previous tribunal. This tribunal cannot supersede that order, Milas.
So that's why you come back to the High Court.
Yeah, exactly, Milas. That's the
But the
reason.
High Court also cannot do anything at this stage.
No, my laws can because it's
No.
only modification. I'm only saying, as my laws have previously directed that the money be kept, the retention money may be kept in a fixed deposit.
See, the thing is that the situation has now changed.
Right, Milas.
It is no longer that the two parties are in arbitration.
Right.
Now it's another party which is in arbitration with one of the parties.
Right, Milas.
So in such a changed situation,
Yes, Milas.
this court may not come back to that period of time where that order was passed and make the modification.
No, my laws can.
I don't
because
think that
under
will
the
be permissible.
My laws can. Under the contract, Milas, 36 clause 36.1 and 48 point, I am entitled to retain the retention money till the time defects are corrected and adjust, Milas. My laws are. It's not that I'm keeping, because I'm entitled under the contract. I have a contractual rights. I have a contractual right under 36, and my laws have also noted in para 16 of my laws order.
Anyway, who's the other party?
JKM,
This-
Milas, JKM.
JK.
Yeah.
No, you are the petitioner here.
Yeah, I'm the applicant here,
You are
Milas.
the applicant.
Yes, Milas. And JKM is the, yeah.
There are two parties here, JKM and APS.
APS, because I had to make all of them a party, Milas. I have no, there's no relief against APS. It's
So
only JKM.
as of today, I think we'll have to issue notice.
Very well, Milas. My laws may issue notice. I'll
You are
satisfy
Mr.
my-
Aroy. You are Mr. Aroy.
Yes, Ajoy Roy, Milas. Ajoy.
Heard Mr. Ajoy Roy through RVC, who submits that by filing this IA, the applicants seek modification of the judgment and order dated 8/3/2024, passed by this court in WPC number 80 of 2022, insofar as the retention money insofar as the balance retention money is concerned. Stop. The learned counsel submits that the arbitral the arbitration between the parties concerned ended with a settlement between the parties, and for which and as for the retention money, it has been agreed that the same be divided into in the ratio of
75-25, Milas.
Who will get 75? JKM
APS, Milos, APS.
in the ratio of 25:75 between the opposite party numbers 1 and 2 respectively
Yes,
in the instant application. Stop. While 75% of the retention money has already been released to the
Opposite party number 2, Milos.
opposite
APS.
party number 2, the balance of 25% of the retention money remains. Stop. The opposite party number 1, in the meantime, has instituted another arbitration against the applicants, claiming a sum of rupees 377,74,97,876. To stop, the learned counsel submits that pending finalization of the award, the arbitration case, the retention money, the 25% of the retention money may be directed to be kept in a fixed deposit. By suitably modifying the judgment and order dated 8/3/2024. Next, para issue notice to the opposite parties, public respondents, returnable by 3 weeks. How will you take steps?
We'll file, we will serve them by way of email and by registered post. As per the court order, Milos will comply with.
Petitioner, the applicants to take steps for service of notice upon the opposite party number 1 and 2 through registered post with ADD.
If my lords can give me dusty, that would be ideal, Milos.
Within 3 working days.
Milos, I have one last request, Milos, to make. If my lords has page 80, Milos, they have been sending notice of contempt on me. Though they know they are in arbitration of contempt. So, Milos, till the next date of hearing, Milos, if this order can be put in.
Page 18, where?
Page 80, Milos, page 80.
80.
80, yes, Milos. They have been threatening me with contempt. So, if this order can be put in abeyance till the next date of hearing, Milos. If my lords has a last page 80 para 9, Milos.
Page 80?
80, yes, Milos. Then their contempt notice basically starts from 77 and the operative part is on page 80, Milos.
No, there's no such order can be passed at this stage. Let them appear. But
Yeah, I'm only requesting, Milos. I'm only saying till the next date of hearing, this order may be kept in abeyance. Because they're threatening me with contempt, Milos.
Maybe you tell them.
Oh.
File IA.
Very well, Milos. I'll do
Just
that.
again after 3 weeks.
Very well, Milos. Grateful, Milos.
Send me that thing. I'll sign it.